Welcome to our channel, everyone. My name is Aman. I'm a regulated Canadian immigration consultant. And if you have watched my videos on this channel before, you probably understand what kind of content I make and how it's going to help you in your Canadian journeys. If you're new to the channel, I'd like to welcome you, and I can assure you whatever you're going to see in this video or any other video is definitely going to help you in different sector of Canadian immigration. Today we are going to make an important video on procedural fairness and how the decisions given by the immigration department in today's date and even in previous dates have violated the right of procedural fairness of the applicants. Okay, so to understand the whole situation, first thing we need to do is to understand what is procedural fairness. So what is procedural fairness? So if you look at canada.ca and search for procedural fairness and you land on this page, what you're going to see is this, what's on your screen. The procedural fairness says that this section contains policies, procedures, and guidance used by the IRCC staff, and it is posted on the department's website as a courtesy to stakeholders. Who are the stakeholders? The people who have done these applications and the people who are going to be affected by it. The decision makers are required to follow the rules of the procedural fairness throughout the decision making process. So it's not just that they can pick and choose when to apply, when not to apply. They would have to do it throughout the decision making process. And the procedural fairness requires that applicants must be provided with a fair and unbiased assessment of their application. Okay, so it's the immigration officer's duty to review the application and give a fair decision. And the applicants must be informed of the decision maker's concern and have a meaningful opportunity to provide a response to concern about this application. So this is probably a topic for a different video, but in today's video we're going to talk about another requirement of procedural fairness, which is going to come in just a couple minutes in the video. And the requirement of procedural fairness also says that this requirement for procedural fairness applies to all type of immigration and citizenship applications and all aspects of decision making. So any application you do for your immigration, it could be a temporary permit, study permit, work permit, spousal open work permit, visitor visa, PR applications, or any refugee applications. The requirement of applying procedural fairness on the application and the decision making process applies to all applications. Okay, so now the biggest thing which is going to be a main topic of this video is one of the primary elements of procedural fairness. On the screen you can see all of them, but we are going to focus mainly on the right to reason. So when an application is given to Immigration Canada, they have to apply procedural fairness, all of these requirements, but right of reasons, and I'll show you why this is important. So let's see what is right of reason. It says that the applicant has the right to understand the basis of the decision made on the application. So as an applicant, you need to be aware of why this decision has been made and why you are eligible or not eligible for this application. The reasons which should be provided in writing must be clear, precise, and understandable. So your refusal letter needs to make sure that you understand why your application is being refused or approved. When the applicant has the right to make an appeal to IAD or seek judicial review at federal court, the applicant must have sufficient information to prepare the submission. So if you are making a temporary application, which is study permit, visitor permit, or work permit, you do not have the right to appeal to Immigration Appeal Division, because it only hears the appeals for admissibility hearings and appeal for applications for permanent residency and citizenships. Okay. And it's in that situation, if you're applying for a temporary permit, you do actually have the right for a judicial review if you can prove that the application has been declined by an error in applying the immigration law. And procedural fairness is one of those laws. So if you are able to prove that your application has breached the procedural fairness requirement of the law, then you have a basis of taking the applications to the judicial review. For that, you obviously need an immigration lawyer. But I want to make a point here that if you take your application, which is a temporary permit application, to the court through judicial review, it all depends upon if you can prove that there is a breach of law. and that is not going to prompt the judge to give you a new decision. They cannot do that. They can only say that yes, there is a breach of law. They would tell IRCC to assign another officer to review the same application, and maybe the decision which you already received approval or refusal, basically if you're going to the court, you're most likely going for a refusal, it could result in another refusal. That all depends upon how your application was made, but you can actually take your application to judicial review in the federal court if you can prove that there is a breach of law, and the evidence and explanation provided in the application justify getting an approval. Okay, the next line, it says that the reason provided to the applicant should reflect the assessment of the facts and evidence relied upon, and the provisions of the act and the regulations on which the decision is grounded, and the reasoning for the conclusion reached by the decision maker. So it is a lot required by the immigration officers, all the different types of applications, to explain why they made a decision, which factors and evidence they used to make that decision, and how they reached that conclusion. But do you believe that the applications which are being refused and the applications which the refusal reasons which are given to the people have all of this information? I don't believe that, and I'm seeing more and more applications being refused without providing any valid reason, stating which facts and evidence were relied upon when making that decision and how the officer reached that decision. So what I did is I actually applied for something called Access to Information and Privacy Act, and I applied for data on the number of applications going to CPC Edmonton. The reason is that majority of the Indian applications for study permit and visitor permits are going to that office, and I've been seeing many people reaching out to me with refusal letters, which doesn't make any sense. So I decided to check that information and see what's going on. And now let's have a look at the results which I found out. Okay, so this is what came back from IRCC when I asked for the Access to Information report. So this on your screen, it says CN, which is probably Canadian, SDS Consistency Monthly Report, CPC E as in Edmonton, refusals between January 1, 2022 to February 28, 2022. And you can see that from India itself, in January, they refused 3,618 applications. In February, they refused 4,990 applications. I have also asked them to give me the information on how many applications they received, which they did not provide me the information, so that to keep certain privacy on the actual number of applications they are refusing based on the number of applications. Because if they're receiving 4,000 applications in a month and they're refusing 3,618, that's a big problem. So basically it looks like they're just acting as gatekeepers to stop people from coming into Canada, because most likely they have reached the maximum number of people they can allow to come to Canada as students and visitors. So in total, between January 1st, 2022 to February 28, 2022, they have refused 8,608 study visa application SDS stream from India itself. And that is just one office, which is CPC Edmonton, and that's where majority of the applications are going to. And the reason I'm making this video is because I have received multiple refusal letters from different type of people. A couple of my applications were refused without providing any significant reason, and the way the immigration officer reached that decision. Okay. Now the next thing is the top 5 refusal reasons being used by CPC Edmonton and CPC Ottawa, because these are the 2 offices which are taking care of most of the applications from specifically India. You can see 8,401 applications are refused by stating purpose, IRPR section R216(1) B, purpose of visit. And when these refusal letters come, it says that we are not convinced you will leave Canada at the end of your duration of stay because of your purpose of visit. And that's it. No other explanation provided in the refusal letters, and no explanation provided why the immigration officer believes that the purpose of visit is not genuine, which is basically coming to Canada and studying in Canada. Okay, so having said all of that, now I hope you understand what is procedural fairness, what is the requirement of Immigration Canada, the IRCC's officers to apply that on all of your applications, and providing reasoning for your refusal, the facts and evidence they relied on while making the decision, and how they arrived on the decision. And you can tell me that if you are looking at any of your refusal reasons, are they following any of these procedural fairness requirements? Now, let's quickly have a look at this refusal letter, which was sent to me by a gentleman on August 5, which was yesterday. And I want to just show you the date. And now let's go on and check what is written in the refusal letter. It says that I am not satisfied that you will leave Canada at the end of your stay as required by the paragraph 216(1)(b), which I just showed you, one of the reasons of IRPR, and they give the link to that. And it says, I am refusing your application because you have not established that you will leave Canada based on the following factors. And my friends, I think we need some kind of divine intervention or magic to understand the factors, because they have not provided any in the application. So you be the judge. You tell me that is it a breach of the procedural fairness if you understand what we discussed in the application so far, the video so far, that what is procedural fairness, and are they following the requirement of procedural fairness? If not, what is the repercussion IRCC is having on making such decisions and giving such letters, and spend the people who are spending all of this time and money in doing these applications? And because India is one of the biggest immigration market for Canada, and if they are doing exactly the same to their biggest market, why is nobody speaking about it? Why is the different parties who are either in power or not letting these kind of things happen to one of their biggest immigration market? Decision is yours, and I think actions are yours to take. Maybe you should be reaching out to your local MLAs and MPs and informing them about these problems, and maybe they would be able to do something about it, so we can get better decisions from Immigration and Refugee Citizenship Canada, and maybe get better letters explaining why they reached that decision, so people can actually prepare, which is also a requirement of procedural fairness, that people should be able to prepare their appeals or their judicial review applications based on the information. Now, what is happening is that they are providing more and more refusal letters like this, leaving people stranded. The only options left with them is to apply for GCMS notes, which takes about 40 days to come. And in the meantime, majority of the students are losing their intakes. Maybe if this person has applied for September, now he doesn't even have any time to figure out what he needs to do to get an approval on the application. Because even, I'm not going to say his application was good or not, was he eligible to come to Canada or not, but he need to have a fighting chance as per the procedural fairness requirement. But based on what information IRCC gave him, he doesn't even know what to fight. So that's definitely a breach of procedural fairness according to me. Your decision is definitely yours. And I guess, like, if looking at this video, if you can do something about it, you can create more awareness about it. Maybe we need to get CPC Edmonton to treat the Indian applications better and at least provide them reasons why they are refusing their application, so people can actually figure out what their next steps are going to be. Okay, thank you. That's all about my rant about CPC Edmonton. Now I'll leave it to you what you want to do. And if you like the contents of this video, please hit the like button, subscribe to the channel, because I am going to keep speaking about the immigration issues, and I'm going to keep bringing these type of videos out for you. And we have many good videos planned for the coming days as well. Thank you very much for watching, and stay safe, please.